Swayam Prabha. Digital India. Educated India.
Hello, I am Dr. Surendra Mehra, Assistant Professor Law Department, Banaras Hindu University, Varanasi. So, this is my 10th topic on revision. We have already discussed 9 topics. In first topic, I have discussed suit of civil nature or jurisdiction related issues, section 9 of CPC. In second lecture, I have discussed res judicata. In third lecture, I have discussed place of suing. In fourth lecture, I have discussed suit by indigent person. In fifth suit by minor. In fifth lecture, I have discussed suit by indigent person. In sixth lecture, I have discussed temporary injunction, order 39 of CPC. In my eighth lecture, I have discussed execution. In ninth lecture, I have discussed various provisions of appeal, first appeal, second appeal and appeal to Supreme Court. And this is 10th topic on revision, and this topic's revision under section 115. This topic is very important. In my earlier lecture or previous lecture, when I was discussing various provisions of appeal, I told you like students are confused with these few provisions: appeal, mainly first appeal, second appeal and appeal to Supreme Court. Then also we have another provision, reference under section 113. Under section 114 we have review provision, and this is 115 revision one. Which authority they should approach in case of appeal, which authority they should approach in case of review, or which authority they should approach for revision, and especially the meaning, basically reference, review and revision, because little bit reference, review and revision, they confuse, basically these provisions confuse the students. So, in this lecture I will try to cover up all those things, and you will come to know the idea behind this one. I mean, what is the exact meaning of this reference, review and revision. So far as appeal is concerned, I told you appeal is a judicial examination of the decision by the higher court. First appeal basically will lie before the appellate court or the higher court, first appellate court as per section 96 of the CPC. Second appeal on substantial question of law before the Honorable High Court. Third appeal under section 109 before the Honorable Supreme Court. And this difference also comes, reference, review, revision and appeal, difference between all these 4 provisions. This question comes sometimes in exams also. So, this provision otherwise also relevant. Reference under section 113, before this revision, I will just let you know little bit about this one provision 113, reference and review also. 113, this deals with reference. Reference, I will write it, you will come to know section 113. Reference means refer the matter before the high court. When subordinate court feels, the meaning of reference I am telling you, and the meaning is there in the word itself, reference, refer the matter before the high court. When subordinate court feels there is a doubt, or there is a doubt relating to the validity of any act, regulation or any ordinance, when the meaning is not clear, whether a particular act, regulation or ordinance is valid one or not, then in that case subordinate court on and on, because this is question of law mainly, refer the matter or get the opinion from the Honorable High Court. So, this application lie, reference application under section 113 lie before the Honorable High Court. Review 114, this is also important one. Review. Review means to look once again, review, section 114, review to look once again by the same court, not by the same judge, by the same court. Review, this is second. So, reference 113, 114, review. To look once again, the meaning of review is to look once again. If you feel there is a problem in the judgment, there is a apparent mistake in the judgment, or on the basis of discovery of new evidence, new fact, new evidence, or any other sufficient reason. Mainly when there is a mistake apparent on the face of the record, patent kind of mistake, which is apparent one, when there is no doubt. Court was in judgment or in statement, court was saying like court will award 9% rate of interest, but now in judgment you find no, this is 7%. So, this is a mistake because, or the name mistake relating to names, Ram versus Ghanshyam, this kind of mistake, if you feel anybody can come to know just because the mistake is apparent one. I am just giving example just for your understanding, because if you are clear on this point, what is review and what is reference, then you can easily relate it with the revision and you can easily come to know the meaning of revision also. When there is an apparent mistake, clear mistake, the mistake which is visible one, when there is no doubt, anybody can, the concerned parties, if they are coming to know the mistake is there, then on that basis also they can file application, they can request to the court under section 114, your lordship kindly look it once again. This is the meaning of review, and this is lie before the same court, whosoever or whatsoever has passed the judgment in your case, civil matter. Third one is revision. Here in this lecture we will discuss revision section 115. Revision is very important. Basically, this is relating to jurisdictional error, jurisdictional issues. I will read first of all the language of this section 115, then I will relate with the examples, I will let you know what is revision. I have written specially ki where, to whom we call, ki this is failure to exercise jurisdiction, or this is illegal or material irregularity. With examples I will clear here what is this revision, because just by coming to know this meaning is not enough. Read this one. The High Court may call for the record of any case which has been decided by any court subordinate to such High Court, because this revision basically is a supervisory power over the subordinate court, and this power is exercised by the Honorable High Court. Supervisory power. If there is a provision of appeal, then revision is not maintainable. Keep it in mind. If there is a appeal is provision of appeal, then revision is not maintainable, because there is a meaning of this one revision, to revise the judgment. When High Court feels so, like, because this is what I am telling you, this is a supervisory power. So, in case of revision, High Court suo moto, or sometime on the basis of the application of the aggrieved party, they can call the record from the subordinate court or the lower court upon which that respective High Court has the supervisory power. You know this thing. Every state has every state has High Court, and below that High Court there are number of subordinate court also. Respective High Court exercise supervisory power over those subordinate courts, like whether there is a jurisdictional kind of error is being committed by the subordinate courts or not, just to keep them within the framework of law. This power is exercised by the Honorable High Court. That is the reason normally High Court visits the subordinate courts once at least in a year. So, this is basically supervisory power. This you have to keep it in mind, supervisory power. There is a popular case for this one also, Shiv Shakti Cooperative Housing Society versus Swaraj Developers, 2003 judgment. We will tell you how this is a supervisory power. Apart from it also, provision 3rd is dealt in this case, supervisory power. So, there is a logic of supervisory power behind this provision of revision. So, first let me start with this one. To have exercised a jurisdiction not vested in it by law. When subordinate court exercising a jurisdiction not vesting in it law, it means a question of want of jurisdiction. want of jurisdiction. This is the case here comes out of it. Want of jurisdiction, have exercised the jurisdiction not vested in it by law. When law is not giving authority to the subordinate court, then subordinate court cannot decide that case. I will let you know even the meaning, any case, what comes, any case which has been decided by any court, what kind of cases, what small thing comes within this purview of this one. To have exercised a jurisdiction not vested in it by law, when there is a clear picture, want of jurisdiction, lower court has no jurisdiction, so subordinate court has no jurisdiction. If even then if lower court is exercising, then high court can call the record of that case, how you have exercised this jurisdiction. And I told you the importance of this word, the meaning of jurisdiction means authority to decide, the meaning of jurisdiction, authority to decide. If you know the meaning, then you can easily come to know authority to decide, authority to decide. This is the meaning of jurisdiction, authority to decide. And how lower court has exercised, and a decree passed by a court without jurisdiction is a null and void. This is the general principle of law. Normally I say this thing, advocate must be vigilant before deciding or before filing any case whether this particular court has jurisdiction or not. Although court has to exercise this power and the question of jurisdiction is always decided by the court, but this becomes the duty of the advocate also. They must understand this one, whether this court, you cannot just by your consent provide any jurisdiction to the court, or you cannot take away this right from the court also. Your consent cannot decide jurisdiction, jurisdiction is decided by the high court, and court has to jurisdiction, already told you, pecuniary jurisdiction cannot go beyond limitation, subject matter jurisdiction, court cannot go beyond subject matter. Whatever work has been allotted by the honorable session judge, then court has to remain within that, court has to handle or and appreciate or entertain only those cases. So it is a question of want of jurisdiction. A decree passed by a court without jurisdiction is null and void, and validity of it can be challenged even in execution proceeding, even in collateral proceeding, in any other case also this can be decided, challenged. So this is first question. I will give examples also, in further slides I have written all those things. Second, failed to exercise a jurisdiction, so wasted. Court has jurisdiction, subordinate court has jurisdiction, but still court is not exercising. This is called failed to exercise. Honorable district courts or courts has jurisdiction to decide the matter, but because of ignorance or lack of knowledge, if they are not exercising it properly, if they are not exercising at all, then this will be the meaning of this one, failure to exercise. To acted in exercise of jurisdiction with illegally or material irregularity. These two words, what is illegally or material irregularity? Material irregularity. The high court may make such order in the case as it think fit. I will give examples what is illegally and material irregularity also. These three things. Provided that the high court shall not under this section vary or reverse any order made or any order deciding an issue in the course of suit or other proceeding, except where the order, if it had been made in favor of the party applying for revision, would have finally disposed of this. This you have to mark out from here to here. I will clear the meaning of this one also, except, from except up to proceeding. The case is there, Swaraj developer case on this point, 2003 judgment, Shiv Shakti Cooperative Housing Society versus Swaraj developer. The second one, high court shall not under the section vary or reverse any decree. A revision shall not operate as a stay of suit unless high court specially pass this order regarding this one. See this explanation. In this section, the expression any case which has been decided, what comes, because there is a language, the high court may call for the record of any case. What does it mean, any case? It means can high court call any kind of things, decree, order, interlocutory orders or other proceedings, when court feels how the subordinate court has exercised jurisdiction over it, when lower court is not having jurisdiction. or how lower court has there is a failure to exercise jurisdiction, or there is a illegality or material irregularity. So, for just understanding this one, the word any case, there is a explanation we have for this one. What comes in explanation? Any case which has been decided includes any order. It means small order. Any order deciding an issue in the course of a suit or other proceeding. It means all the entire civil proceedings. Suit means entire civil proceeding. It includes, any case includes, it means even small order what you are giving. Suppose for example, there is a, you need permission under order 33 of CPC, suit by an indigent person. If the court is rejecting your application or court is giving you opportunity, accepting your application, then this order on application 33, order on application 32, order on application under order 32, suit by minor, this kind of this order will also comes under the purview of this one, any case. Small orders, power to return a plaint, order 7 rule 10, ex parte decree, order 9 rule 6, dismissing case, dismissal for default, or any other amendment of pleading, any small thing, the entire civil proceeding, small issues. It does not mean that only High Court can call the record of decree, or the, I mean, if the High Court is not satisfied with the decree, if the High Court feels no, this decree is not as per the law, only that is not the subject matter, that is not I mean the case, any case. Any case includes all civil proceedings which can be called by, this can happen or this can take place. Suo moto also, High Court suo moto also can call the record from the lower court, show me what you have done, what kind of mistake you have committed, whether there is a failure to exercise jurisdiction or not, whether there is a question of want of jurisdiction or not. Because in beginning itself I told you this is a supervisory power. Through this High Court exercise supervisory power over the subordinate courts. That is the reason High Court can call record of any case. But this is very important. Sometimes student ask this question, sir, what comes any case? What does it mean any case? Any case means includes any order or any order deciding an issue. Small issues, framing of issues. We have discussed number of times in our earlier classes. There can be number of issues in one matter. If there is any problem on any issue, if you approach it directly to the court, if appeal provision is not there, keep this thing also in your mind. If the appeal is available, then you have to approach the appellate court. But if appeal is not there, then revision will be, and depends upon finally whether High Court accept it or not, that is a different thing. But if appeal is there, then no revision. If appeal grounds are the first appeal, it includes first appeal and second appeal both, then no revision. You cannot avail the benefit of both these two remedies simultaneously. Okay, once you file appeal, if it is rejected by the High Court or if it is rejected by the court, then you think no, now let us file revision also on the same ground. No, you cannot do this thing. If appeal is there, then no revision, first appeal or second appeal. So, any case includes all kind of order, interlocutory orders, small orders. I have given examples, amendment of pleadings, return of plaint, ex parte order, or apart from it order on order 32, application suit by minor, suit by indigent person, condonation of delay under Limitation Act 1963. Small orders, because this is part of this is all civil proceeding. These all are part of civil proceedings. They comes under the purview of any case. This is very important. Any case, you cannot take it lightly. Already told you, only decree is not the subject matter of revision. Only final judgment is not the subject matter of revision. Any case. But I will let you know how, whether court will reverse it or not, change it or not. This depends upon this provision, provided and proceeding, except where the order, if it had been made in favor of the party applying for revision, would have finally disposed of the suit or other proceeding. If the answer is yes, only then High Court or revision is maintainable. If High Court shall not under this section vary or reverse, you have to relate this one, and this is the crux of this Swaraj developer case also. Under this section vary or reverse any order made or any order deciding an issue in the course of suit or other proceeding, except where the order, if it had been made in favor of the party applying for revision. If High Court, suppose High Court passes the order, if it is in favor of the party, and if that order finally disposes of the suit, then High Court will vary or reverse the order. Otherwise, High Court, it means only then revision is maintainable, otherwise revision is not maintainable. Now, the question is very clear, the picture is very clear. Interim orders are not, although in explanation, just if you read simple language of this explanation, you can come to know, no sir, this every order comes in this picture. But what I am saying here, if order is finally disposing this suit in favor of the party, then High Court will vary or reverse the judgment or order. Otherwise, it means revision is maintainable only in that case. If answer is yes, this is in favor of the party and would finally dispose of the suit, then High Court will reverse, it means revision is maintainable. Otherwise, if answer is no, then no revision. This is the crux of Swaraj developer case, Shiv Shakti Housing Cooperative Housing Society versus Swaraj developer judgment, 2003 judgment. So, you cannot go by this explanation only. If you just plain read this explanation, that is not the exactly, you have to get the idea from the judgment, like what I have told you already. Otherwise, High Court will not reverse. So, interim orders are basically, apart from this, interim orders or interlocutory orders are not finally disposing the suit. If I say otherwise, interim orders or interlocutory orders, what you have studied under order 39 of CPC from rule 6 to 10, apart from it also number of examples I have given. If it is not disposing of your suit, interim orders do not dispose, this is temporary injunction, they do not dispose the matter finally. So, it means the one line sentence or one line crux of this one, Swaraj developer, it means in case of interim orders, there is no revision. But explanation says any case which has been decided includes any order made or any order deciding an issue in the course of a suit or other proceeding. It means any order, for any order you can go in revision. No. To understand this one, read this case. This one, Shiv Shakti Housing, Cooperative Housing Society versus Swaraj developers. 2003 judgment. I am pointing out it again, repeating it again, because student asked this question number of times. Sir, what does it mean? The meaning of any case. What does it mean? Except where the order, if it had been made in favor of the party applying for revision, would have finally disposed of the suit or other proceeding. What does it mean? So, I told you what is the meaning of this one, any case. There is an explanation also for this one, but you have to keep only one thing in your mind. If it is disposing the suit finally, then High Court will vary or reverse or revision is maintainable. If the answer is no, then revision is not maintainable, if the decision is not in favor or if the decision is not finally disposing the suit. Or in crux, you can say for interim orders, normally there is no revision if that, because interim orders do not decide the case finally. They may or may decide the case finally, depends upon the, I mean case to case, it varies case to case. You have to see this one also. Now, see this one, this is what I wanted to tell you specially. These are the conditions basically what I have already discussed, but now here I will tell you, clear it with the help of examples. There must have been a case decided by the subordinate cause, this is what I have cleared. Second one, the court deciding the case must be one subordinate to the High Court, this is the second condition. Third one, the case must be one in which no appeal lies. Already cleared this one also. No appeal. Fourth one, this is important here. The subordinate court must have in the decision of the case exercised a jurisdiction not vested in it by law. Here in bare act you will get only these 4 points, and further this points what is exercise the jurisdiction, because this is related basically jurisdictional error. Jurisdictional error, and jurisdictional error are really very serious one. You cannot decide your case without, if you do not have any jurisdiction on the matter, subject matter jurisdiction, pecuniary jurisdiction, territorial jurisdiction, appellate jurisdiction, original jurisdiction. Court cannot decide if they do not have jurisdiction. So, here we have to understand what is the meaning of exercising a jurisdiction not vested in it law. It means when lower court decided a case without jurisdiction, they do not have jurisdiction. With the examples you will come to know. The lower court decrees a suit, first example of this one, when high court can interfere in revision. And what is the meaning of this one? Exercised a jurisdiction not vested in it by law. The lower court decrees a suit for possession under section 9 of the specific relief act when the plaintiff has not been dispossessed otherwise than in due course of law. It means in due course you can dispossess someone. In due course of law, if you are really legally entitled of your property, then you, and somebody is dispossessing you, then you can dispossess him. And high court or the lower subordinate court, without, I mean, overlooking this position section 9 of CPC or the basic principle of this law, because only this legal due course of law decides whether you have jurisdiction or not. Exercising a jurisdiction not vested in it by law. Otherwise, this would be a case of jurisdiction not vested in it by law. Court has not said this one, ki okay, you can decide any case, whatever you feel, ki this is okay, this is good one. If there is a violation of law, only then you can interfere. Section 9 is specifically saying lower court decrees a suit, passed a decree on this point for possession under section 9 of the specific relief act when the plaintiff has not been dispossessed otherwise than in due course of law. If there is a violation of due course of law, then dispossession is okay. But if there is no violation of due course of law, then this is the meaning what I am trying to tell you. Due course of law, there must be a violation of due course of law. And if court is overlooking this provision, whether there is a violation of law or not, and without keeping in mind or considering this one, passes a decree under section 9 for possession in specific relief act, then this is a clear violation of exercising a jurisdiction not vested. Court has not been vested with this jurisdiction. Lower courts has not been vested. Second one, the lower appellate court entertains an appeal from an order from which no appeal lies. Already told you there is a provision, order 43, appealable order. Every order is not appealable one, but order 43 in your various provision of appeal you will find this one also. Appealable order. What are appealable orders? If appeal is not maintainable, if appeal is not permissible, as per order 43, you can go through 43, then you will come to know what are appealable orders, because every order is not appealable. Decree is appealable. Section 96 specifically talks this one. Every decree is appealable. Even decree against small causes court, by decision by the small causes court, where the subject matter or money is crossing, the amount is crossing more than, amount is more than 10,000 rupees, even in that case first appeal is appealable. In consent decree there is no appeal, but against ex parte decree there is a appeal. Section 96, there are 4 provisions in section 96, first appeal. Order 43 specifically talks about appealable orders. If your order or if your appealable order, what to whom or against whom you are approaching the court, against particular order, if you are approaching the court, then you have to find, see order 43 of CPC. There is a clear cut list, although the list is not exhaustive, but at least with the help of that list 43, you can come to know only these are the orders which are appealable, otherwise rest of the orders are not appealable. Against every order, this is the difference between decree and order. Decree is always final, but orders may or may not final. Decrees are appealable, but orders are not appealable. There are only few orders as per order 43 of CPC, only those orders are applicable, otherwise every order is not applicable one. But here what this example is saying, lower appellate court entertains an appeal from an order from which no appeal lies. Appeal is not maintainable, but you are accepting that appeal. So, this is a clear cut case of exercising a jurisdiction not vested in it by law. Law is not granting you this jurisdiction or giving you this jurisdiction. This is second example of this one, exercising a jurisdiction not vested in it by law. Third one, the lower court dismisses a suit for non-production of document. Dismisses a suit for non-production of document. Again, this can be a ground of dismisses a suit for non-production of document. You at least you should give opportunity. Non-production, suppose sometime document are in your possession, sometime for the timing if the documents are not in possession. I given you example of public and private document. Then in that case, lower court entertains a suit or appeal which it has no jurisdiction to entertain. Lower court cannot entertain your suit or appeal if they do not have jurisdiction, because jurisdiction, this is the crucial point of jurisdictional error. This is called jurisdictional error. Court will decide your matter as per the jurisdiction, authority to decide. This is the meaning of jurisdiction. So, lawyer must be cautious before filing any case, before filing any appeal, whether particular court has jurisdiction or not. And you write in the plaint, this is the last part of your plaint, if you have seen any plaint. This honorable court has jurisdiction to decide this matter without knowing. Although court will inquire this one, court will not go or proceed further unless and until court finalize this one, whether this court has jurisdiction or not. But suppose court is not taking into account this one, court is also not understanding. So, sometime this also happens. There are number of, I have seen in practice you will find number of cases are being decided or being tried by the court, those court which they do not have jurisdiction. So, then subsequently what happens? This would waste your time. After 2 years or after 6 months, if you are coming to know this court has no jurisdiction, or court is coming to know this court has no jurisdiction, then finally court will return the plaint under order 7 rule 10 of CPC, return the plaint and direct the advocate, no Mr. Advocate, you should go before this court. Court will take into account, that subsequent court will also take into account the proceeding what has already taken place, because it is a question of interest of justice, question of interest of parties. But at least you should imagine this one, how this kind of trial can also take place. So, advocate must be cautious. Normally this is not happening, but sometimes in some of the cases this happens also. So, this is covering those things also. Lower court cannot entertain a suit or appeal which it has no jurisdiction to entertain. Already told you this one, a decree passed by court without jurisdiction is null and void. This funda or this general principle of law, parties must always keep it in mind. This would be a direct loss to the party. Third, last one, the lower court allows an application to withdraw a suit contrary to the provision of order 43. In order 43 rule 1, we have specific provision in CPC when you can withdraw a suit. When you can withdraw a suit with the permission or without the permission of the court, how you can withdraw a suit. Without the permission, if you are withdrawing the suit without permission, then subsequently you cannot file. If you are getting permission from the court for withdrawing a suit, then subsequently you can file. There is a provision in order 23 rule 1. So, court cannot go beyond. This is a clear cut case of exercising a jurisdiction not vested in it by law. It means lower courts or subordinate courts cannot go beyond the law. Sometimes in the name of discretion and normally this first year students they get confused with this word discretion. No, sir, court has discretion, court can do anything. No, court cannot do anything. They have to remain themselves within the law. They cannot go beyond law. This is the limitation on them. Now, second part of this one, jurisdictional error, because this is the part must have in the decision of the case, subordinate court must have committed jurisdictional error in the decision of this jurisdictional error will come here, jurisdictional error. You can mention here, I have jurisdictional error. Second one, failure to exercise a jurisdiction. To whom you will call ki this is failure to exercise. First question was of exercising a jurisdiction not vested in it law. It means the question was of want of jurisdiction. There is a difference between want of jurisdiction and irregular exercise of jurisdiction. The first ground was on want of jurisdiction, when court had no jurisdiction, and without having jurisdiction, how lower court is deciding your case. Then high court can call record from any record of any case, shoe moto or on the application of the party, aggrieved party. This is called revision. And this is the case of failure to exercise jurisdiction, when lower court have jurisdiction, but still lower court is not exercising it. They have jurisdiction, but they are not exercising. Previous case was of court was not having jurisdiction at all and deciding the matter, and here in this case court has jurisdiction, but court is not deciding as per the jurisdiction. See first example, where a suit is dismissed without trial on a misapprehension on the scope of section 9 of the specific relief act, dismissed without trial. Can court do it without trial? How can you say that without trial you are disposing the matter, dismissing the suit without trial? If there is a plaint, then court must hear the concerned parties, court must appreciate the case as well as evidence, primary and secondary evidence. On the first date of hearing, court must appreciate if there is a logical case, if there is a relevant case, if there is a proper cause of action. If there is a proper cause of action, then court is bound to accept, because this is inherent right. In appeal also I told you the difference between inherent right and statutory right. Inherent right, court cannot, if you are filing your suit, then that is your inherent right. Court cannot say, if you are proving your case on the first date of hearing, if you are in clubbing primary and secondary evidence, then court cannot deny you from trial. Court cannot reject your trial, court cannot dismiss your case, dismiss the case without trial, because trial is your right. OD ultum partum, opportunity of hearing, principle of natural justice. This is directly related, trial is directly related with this one, because trial gives you opportunity of hearing, a complete opportunity of hearing. You will get the decision on merit of the case. If there is no trial, then there is no judgment. Then the decision, I mean the case would not be decided on merit. So court cannot. Second one, where the court refused to summon the deponent on an affidavit for cross examination, refused to summon the deponent. Court cannot, if you are giving, because you people are giving, submitting a list of witnesses as per the issues, whatever has been framed as per order 14 of CPC. Court invites list of witnesses from the plaintiff as well as defendant. Submit, Mr. Advocate, list of witnesses. Plaintiff will submit separately and defendant will submit separately list of witnesses. They will be examined. Court will tick mark all those to whom the court should called and to whom court should not called. So this is cross examination. Court cannot, if you are submitting list of witnesses, if you are saying that this party should be, you want to cross examine, after chief examination, this cross examination takes place. If you are asking permission to cross examine the witness, then court cannot deny it. If court is denying, this is again failure to exercise. Court refused, court cannot refuse to summon the deponent. Court must summon the deponent. Next, this is failure to exercise. I am giving examples, otherwise just knowing this one, what is not vesting in it law, jurisdiction not vesting in it law. Second, what is exercising of jurisdiction, failure to exercise, you will not come to know this one. This is another. An erroneous decision on the question of estoppel would lead to failure to exercise jurisdiction. Erroneous decision on the question of estoppel. Estoppel under section 115 of your Evidence Act. Evidence Act tell you what is estoppel. Like if you are promising somebody, subsequently you cannot go back from your promise if the opposite party is changing his or her position on the basis of your promise. So there must be a proper representation. You cannot say tomorrow, no, I haven't given this representation, although I am changing my position on the basis of your representation. This is estoppel. you should read this provision section 115. So, erroneous decision on the question of estoppel would lead to failure to exercise. If there is a erroneous decision, if this kind of issue of estoppel is coming before the court, then that is also failure to exercise. Next, failure of the executing court to construe a decree. Executing court means under order 21. Execution is very important part of CPC, Civil Procedure Code. Realizing the fruit, execution means realizing the fruits of the decree through judicial process. This is the execution. Order 21 specifically, section 36 to 74 of CPC deals with execution. After getting decree, you apply for execution. You file application under order, the decree holder I mean, file application under order 21 of CPC for execution. So, executing court to construe a decree, failure of the executing court to construe a decree, failure of the executing court to construe a decree. If executing court is not construing your decree, because there are 5 modes of execution in section 51 of CPC: specific delivery, attachment, with sale or without sale, arrest and detention, appointment of receiver, or any other just mode. So, if every executing court is not coming to know this one, what is the meaning of decree, how the court should execute this decree, because through this only execution you will get the fruits of decree. Otherwise, decree, normally I say decree is only a piece of paper. If your judgment debtor is not a good one, he will not give you the benefit of your decree, whatever order you have got from the court. So, that is the reason you file application under order 21 of CPC. Execution, execution, execute, to get it executed, that is execution. So, when executing court is not construing your decree properly, that is also a case of failure to exercise the jurisdiction. Next, when the court has jurisdiction to accept a plaint or an application or to execute a decree or to review a judgment, but refuses to do so on the ground that it has no jurisdiction. Plainly you are saying, if the court is saying no, this court has no jurisdiction, although court cannot say this one without examining, without coming to know the cause of action, but if court is saying so, no, court will not accept this application, court will not accept this plaint, court will not construe this decree, court will not execute this decree. There is a provision in CPC, this is procedural law, every provision is there. You will find, if you read the orders properly and then subsequent rules of that particular order, then you can easily come to know, and on that basis you draft your application and file before the court of law. Court cannot say this thing, the court has no jurisdiction, although if the jurisdiction is not there, then that is a different thing. But if the jurisdiction is there and just without coming to know the plaint, without coming to know the nature of plaint or application, court cannot deny you. This would be a clear case of failure to exercise a jurisdiction. We are talking about revision 115 of CPC. Otherwise, High Court can call your record of your case. High Court has supervisory power over the subordinate court. High Court, Honorable High Court can call record from the lower court, how you are exercising, or you have power, you have jurisdiction, but still you are not exercising, rejecting application or this application, or you are not construing decree properly. This would become a ground of revision. Concerned parties can approach the Honorable High Court. Otherwise, also High Court suo moto also can call the record if you are committing this kind of errors. So, you have to be very cautious when you are sitting on the dais. If you are judicial officer, then you have to be very cautious. If you become judicial officer, then you have to be very cautious. You should be cautious about the jurisdiction, what kind of jurisdiction you have or you do not have. This is third. Next one, where the subordinate court refuse to allow an assignee to execute a decree, rejection of a counter claim on the ground that the original suit has been dismissed for default. These are few other grounds of failure to exercise. Now, third one, the same in fourth part of this section 115, all these things come first. When the court is not exercising jurisdiction, court has no jurisdiction. Second one, failure to exercise, and third one, illegally or material irregularity, to whom you will say this is illegality, what is being committed by or what has been committed by the lower court. This is material irregularity, what has been committed by the lower court. So, in the following cases, see this one, I will directly come on these points, what to whom you will call jurisdiction illegally or material irregularity, where the lower court passes a decree on an unstamped hundi or promissory note. Hundi, unstamped hundi or promissory note, these are Hundi now this concept is no more, but we have Negotiable Instrument Act, promissory note, bill of exchange and check. These are three instrument of negotiable instrument. These are three negotiable instrument. These we have created this legislation just because you cannot carry big amount of money in your pocket. Through check you can, I mean, do any kind of transaction of any up to any amount. That's the reason, this is the benefit of this one. Transaction crores of rupees, but you cannot keep in your pocket. Promissory note is also one thing. But earlier we used to call it hundi. So that's the reason we have, I mean, this word is also there in. So if lower court passes a decree on an unstamped, is there any meaning of unstamped promissory note? Stamped promissory note, check or this one bill of exchange, this becomes relevant when there is a stamp, when you know who has issued this one promissory note, when there is a authenticity, when there is a credit of that particular one who is issuing the promissory note. But the lower court passing a decree on an unstamped promissory note, this would be a clear illegality. Can you issue a check without your signature? No, there must be a signature and the signature must be of the same nature also. Otherwise, bank will reject your application, reject your check. So, illegally and material irregularity, you cannot do this thing. This is a supervisory power over the subordinate court. So, lower court cannot do this kind of thing. Second one, where the lower court decides a case against a person without hearing him, can court decide your case without hearing you? Again, this would be a violation of natural justice. Odi alteram partem, there are two principles of natural justice, odi alteram partem and nemo judex in causa sua. Odi alteram partem means opportunity of hearing, and opportunity of hearing includes all things. It includes hearing, even complete notice, at what time summons, what to whom you call, sometimes summons also, at what time you have to appear, where to appear, before whom you have to appear, reasonable time, including even along with plaint, copy of plaint. Otherwise, you can call it, this notice is not complete one, this summon is not complete one. If the summon is not complete one, this would be again violation of this opportunity of hearing, odi alteram partem. And you cannot do this thing, court cannot do this thing. Without hearing your case, court cannot decide your matter. And one more thing apart from this one, order must be speaking one. There must be some reason, and court write reason or court mention reasons when there is a proper trial, proper hearing of the both parties, hearing of the plaintiff as well as defendant. Otherwise, they will say, if you are not hearing or appreciating evidence or hearing plaintiff, either plaintiff or defendant, they can say tomorrow, no, this is a violation of my natural justice. I asked number of times, I filed this application, but court rejected my application, and this without any reason, without hearing me, court decided. So that's the reason there is a proper argument takes place, proper civil proceedings are there. You have very much opportunity to both the parties. So decision must be, lower court decides a case against a person without hearing him, cannot. This would be illegal and material irregularity. This is material one. High court can take action as per the authority. They can call the record. Lower court cannot deny your case without, or cannot decide your case without giving an opportunity of hearing. Another one, when it decides a case without considering the evidence on record. See, this one was without considering the evidence on record. Normally, I suggest to students, whatever the objection you have relating to evidence, primary evidence or secondary evidence, or any proceeding, at least you should object before the court if you have any objection. That must be on record. Whether the objection is sustained or overruled by the court, that's a different thing, but you must bring it on record, because lower court cannot decide a case without considering the evidence. Court cannot decide the case without considering the evidence, because this is the big, lower courts are courts of fact, and they are bound by the evidence. They are bound to appreciate the evidence, whether they accept it or not, that is a different. There must be some logic, there must be some answer for this one, reason for this one, why the court is not accepting your evidence, why the court is not accepting your evidence as well as rejecting your application. So there must be proper appreciation, judicial application of mind on your evidence. why the court is rejecting, why the court is accepting. Judicial application of mind must be based on some sound principles. Straightforwardly court cannot say this one, no, I mean court will not accept this evidence. Where the lower court decides the case without considering the material placed before it in disregard of the evidence, without considering the material, it means all fact whatever you have in the form of plaint, in the form of evidence, in the form of written statement, or in the form of other things, other record, whatever you placed before the court, that must be considered by the court. Court cannot, otherwise this would be again illegality. I am telling you the meaning of illegally or material irregularity, because this is a jurisdictional error. This is very serious one. Another one, where the lower court decides an evidence not legally taken or otherwise inadmissible, decides an evidence not legally taken, otherwise inadmissible. Court must take your evidence legally through proper channel or proper, the way is there, cannot accept any illegal evidence also, inadmissible evidence I mean. Court cannot accept inadmissible evidence, there must be a proper admission for this one. Another one, where the lower court decides without giving reasons for the judgment, there must be reason, the order must be speaking one, we have discussed earlier also. Where the court merely gives a finding and does not decide the suit in accordance with the finding. Findings, your decision of the lower court or subordinate court must be based on the findings. Court cannot, in the name of discretion, cannot say anything, cannot decide anything. If there is a finding on any particular point, on any particular issue, whatever has been framed as per order 14 of CPC, whatever the evidence is there as per the issues, and whatever the finding is there, that decision must be based on that. You cannot put forward, or you cannot say, bring your own logic without any reasonable ground in the judgment. So court is bound by that, otherwise high court, the revision is there, high court can call the record. If appeal is not there, then high court definitely can call the record from the party, from the court. Another one, where the lower court passes a decree for which there is no evidence at all to support it, passes a decree without evidence, again court cannot decide. These are examples actually, I am just telling you the meaning of these examples, because you will come to know what is jurisdictional error. Otherwise really this becomes a question of dilemma for the student. Sir, what the revision, we are confused with revision, we are confused with appeal, we are confused with review. But if you understand these examples, then you cannot, you will not be confused. Another one, where the evidence is obviously valueless, without, if there is no evidence at all, evidence is without value, relevant and irrelevant evidence. On irrelevant evidence court will not pass any judgment, otherwise revision, this would be illegal and material irregularity. Where the tools of an artisan are attached in execution of a decree contrary to section 60 of CPC code, execution. I told you yesterday also, in execution section 60 basically talks about the property which can be attached and which cannot be attached, the same thing is there in section 60. And tools of artisans are basic thing, wearing apparels, tools, ornaments of ladies, tools of agriculturists, these properties cannot be attached. But if court is attaching these basic necessities, basic properties, otherwise how the parties would survive, how the judgment debtor will survive, then this is also a clear cut case of illegality or material irregularity. Another one, where the lower court orders the execution of a decree not executable, orders the execution of a decree not executable. There are 5 modes of execution and you have to find out whether this decree is executable or not. There can be some natures, like suppose there is a, I mean, can you compel, although now late Sri Lata Mangeshkar is not here, but can you compel, if she had been there, can you compel that Lata Mangeshkar for her voice? This is her will, whether she want to sing or not, or any other singer right now whosoever is alive now. Can you compel that? No, you cannot. So this, if this is the nature of the decree, then this kind of decree is not executable. Decree is executable. So in specific relief act we have few examples, section 10 and 14, which are where compensation in terms of money is possible, then no execution. Where the lower court passes decree on compromise by the guardian without inquiring whether it was for the benefit of the minor or not. Order 32 of CPC. This would be illegal or material irregularity. Guardian must take permission from the court. Next friend must take permission from the court. Otherwise, court will not pass or accept this kind of compromise if it is taking place by the guardian without inquiring whether this is for the benefit of the minor or not. This would be a material irregularity. This would be illegality. Another one, where the lower court confirms sale in execution, disregard of stay order by the same court in another proceeding. This is also another example, and these are other considerations. Interest of justice, otherwise interlocutory character of the orders, another remedy to an aggrieved party by way of appeal, the general equity of the case being served, general equity. These are other considerations to decide if your case is not falling within that earlier criteria, not no jurisdiction or failure to exercise jurisdiction. Third one, illegality or material irregularity, and fourth one is this one. So, I hope if you take these grounds seriously, read these grounds seriously, even in my PPT, then you can easily come to know what is jurisdictional error. And these are few more things, you can read it out just for say, there is a this Chandu Ambedkar versus Digambar, and so far as Shiv Shakti Housing Cooperative Society versus Swaraj Developers, I already cleared you what does it mean, explanation meaning, and that one what comes any case, what is the meaning of any case decided by the subordinate court. Explanation saying this would include order or any proceeding, but Swaraj Developers case is saying no, if this is not for the benefit, if it is not disposing any order, interlocutory order is not disposing the case finally, then high court will not, honorable high court will not reverse or vary the judgment, vary the order. It means revision would not be maintainable in that case, but if it is finally disposing the case, then revision is maintainable or high court can vary and change the decision or vary the decision. Finally, interim orders are not, because they are not deciding the case finally, so no revision. Yes or no answer, no revision, because they are not deciding the case. So, explanation plus section 115, this third part of this one, you have to club this one, and with the help of Swaraj Developers, Shiv Shakti versus Swaraj Developer case, you can understand. This is another one. Chandu Ambedkar versus Digambar Kulkarni. Right of appeal is a substantial, but there is no such substantive right in making an application. Right of appeal is a substantial one, but this application under section 115 is no a substantial one. This is just for the supervision, the subordinate court, supervision the subordinate court. I told you in beginning, it does not in any way confer a right on a litigant aggrieved by order of the subordinate court to approach the high court for relief, and thus the scope of revising section 115 is not linked with a substantive right, because 115 revision deals with only your substantive right. 115 revision is not a substantive right, appeal is a substantive right. If there is no appeal, then you can, or appeal is maintainable. Appeal is a substantive right, but this is only 115 is only a supervisory power of high court over the subordinate courts. So, this is all about reference, review and revision. I have covered although reference and revision in brief just for the understanding, because otherwise you will not understand revision properly. I cleared you. Reference means refer the matter before the high court. Review means just to look once again by the same court. Application would be under 114 before the same court. Revision means before the high court on these jurisdictional error grounds. Thank you.